So my name is Christy Cosma, and I'm the co-head of events at European Guanxi. I'll be your moderator for this event as we explore how two global powers like China and the European Union are shaping the future of generative AI through regulation. As artificial intelligence continues to evolve rapidly, understanding the regulatory approaches of key actors like China and the European Union is essential, and that is why um, this session aims to offer insights into the regulatory philosophies, governance mechanisms, and ongoing challenges that both the EU and China are facing. We're thrilled to be joined today by two distinguished speakers who will share their expertise and perspectives on this topic. And each of them will deliver a short presentation followed by a discussion round and audience Q&A. Before I introduce the speakers, I would like to give you just a brief overview of the topic. So the European Union has taken a proactive, risk-based approach with the Artificial Intelligence Act, the first comprehensive AI law of its kind. This regulation classifies AI systems into four risk categories: unacceptable, high, limited, and minimal risk. The AI Act will be fully enforceable by August 2026, though some provisions take effect as early as February 2025. On the other hand, China regulates AI through targeted administrative measures focusing on content control, national security, and social stability. China's cyberspace administration plays a leading role in enforcing these rules, ensuring AI supports the country's broader governance goals. So we see here that while the EU prioritizes individual rights and data protection, China's approach is more state-centric, focusing on controlling AI's societal impact and mitigating risks through strict oversight. However, despite their differences, the EU and China have engaged in AI policy dialogues to explore areas for cooperation, notably during the China EU high level digital dialogue in September 2023. Both sides discussed AI development, regulation, and ethical considerations. To learn more on this topic, I would like to introduce our speakers for today. Um, Maybe I can start with Giorgos Verdi. Mr. Verdi is a policy fellow with the European Power Program at the European Council on Foreign Relations. His research focuses on the implications of critical and emerging technologies for the EU's competitiveness, economic security, and foreign policy. Before joining the European Council on Foreign Relations, Verdi was a policy advisor to the European Digital SME Alliance, where he worked with high-tech small and medium enterprises and startups. He has also worked with the European Parliament and the Hellenic Foundation for European and Foreign Policy. Verdi holds an MA in EU International Relations and Diplomacy from the College of Europe and a BA in International Relations from the University of Piraeus. Next, I have the pleasure of introducing Dr. Sara Migliorini. Dr. Migliorini is an assistant professor of global legal studies at the Faculty of Law of the University of Macau. Sara's research covers global legal issues with a focus on technology law and regulation. She's widely published in her field, and her writings have been cited several times by the Court of Justice of the European Union. Sara also led preparatory work for the European Commission in the field of international and technology law. Before joining the University of Macau, Sara held the position of research fellow in private international law at the British Institute of International and Comparative Law, and other research and teaching positions at the University of Paris 1, Pantheon Sorbonne, London, Lausanne, and Florence. Sara holds a PhD from the European University Institute and a master's degree from the University of Paris 1, Pantheon Sorbonne. Sara is also admitted to practice law in France. Without further ado, I'd like to give the floor to Mr. Verdi. Mr. Verdi, the floor is yours. Thank you.
Thank you so much, Christy, and thank you for the invitation. It's really exciting to be here and discuss such an important topic. So what I want to talk to you a little bit about today is the EU's approach to artificial intelligence. And the way I was planning to do that is spend firstly a few minutes talking about the EU's regulatory approach, and then later dedicating some remarks on the EU's competitiveness agenda as well, that has become increasingly important and is very much tied to the EU's regulation on AI as well. Later on, we can also have a discussion and start bridging the gaps between the EU's and China's approach too. So let me start before going into the EU's regulatory approach. Let me start with an observation that we live in an era of rapid advancements in the field of artificial intelligence. There are a lot of resources right now being dedicated to the field. So for example, from 2010 and every year since then, the amount of computing power that is used to train AI models is doubling every 6 months. So that is, first of all, we see a lot of increase in terms of computing resources going to train AI models, but we also have a lot of investments pouring into the sector. So in 2019, there were about less than $3 billion being invested in the field of generative AI. Fast forward 6 years later to 2025, that amount has grown by a factor of 9, and we have about $25.2 billion being invested solely in generative AI. And it is exactly this kind of resource mobilization that has led to some impressive models and some impressive results. I'm not going to waste a lot of time talking about ChatGPT. I'm sure you're all very much familiar with it. It's a very impressive chatbot based on a foundation model called GPT-4. But back when it was released in December 2022, ChatGPT captured the attention of policymakers and also of the general public because it became a bit of a reference point of the kind of capabilities that generative AI models can possess. Now, all this is important because it provides context, because it is exactly in this context that EU policymakers started thinking about the potential to regulate these products, because the reasoning here was that as these products began proliferating into our everyday lives and began being integrated into businesses, then we might see consumers and citizens being exposed to potential risks that AI systems pose. And by this point, by the point that policymakers in the EU start discussing about AI, these risks weren't just theoretical. So let me give you a couple of examples to highlight these kinds of risks. In 2019, the Dutch government was involved in a scandal after the country's tax authorities used a self-learning algorithm to create risk profiles in order to spot fraud among people applying for childcare benefits. Now, this self-learning algorithm, the risk indicators that were input marked things such as having a dual nationality as a big risk indicator and also having low income. And as a result of this, about 20,000 parents were mistakenly labeled as fraudsters and were asked to pay back what they had received from the government without proof that they had committed such fraud. Let me give you another example that highlight the risks that AI systems can pose in our everyday lives. In 2014, a team of engineers at Amazon began working at an algorithm with the aim to automate the hiring process in this company. So the task was to build a self-learning algorithm that could review CVs and determine which applicants Amazon should bring on board. Now, this project was dropped just a year later because it became very clear that the tool discriminated against women applying for technical jobs, such as software engineering positions. And it was because the existing pool of Amazon software engineers was overwhelmingly male, and the new software was fed data about these engineers' resumes that it ended up having those biases being replicated by the final system. So it's in this context of these growing AI capabilities and these risks that they pose to consumers and citizens that the European Union proposed the Artificial Intelligence Act back in 2021 with the aim to prevent such risks from materializing and protect citizens and consumers. Now, the AI Act, as you might know, was the world's first AI regulation trying to achieve such thing. Now, to understand the structure of the AI Act, I think it will be useful at this point to share a very simple slide with you. All right. So you should all be able to look at my screen. Can I get a little thumbs up if you are able to do so? Thank you very much. So here you can see how the AI Act is structured, and it follows this risk-based approach where AI systems are classified based on the potential risk they pose, and then specific obligations are attached to that risk. So there are three main categories that I'm going to talk about, and then a couple of more that I'm going to explain later. So the first kind of category that you see right on the top of that pyramid is the unacceptable risk category, where AI systems falling under this category are prohibited. What are some kind of systems falling under the prohibited risk? As Christy actually mentioned in his introduction, so-called social scoring systems utilizing AI are deemed to have unacceptable risk and are prohibited from the single market. AI systems considered to be manipulative or employing subliminal techniques are also considered to pose unacceptable risks and are prohibited. AI systems that aim to predict crime based on the individual characteristics of a person or based on profiling are also deemed to have unacceptable risk and are prohibited. There are a couple of more of use cases, but here the idea, as you can see on the left of the pyramid, is that the violation of EU fundamental rights is so severe that the EU decides to not allow the systems to be deployed in the single market. Now, the biggest category of can you guys hear me or see me? I see myself a little bit frozen.
Yes, we can hear you.
Fantastic. I'm going to continue then. The second category is the category of high-risk AI systems. And this is where the majority of the EU's approach is focused on. Now, these are AI systems that are allowed in the single market, but because of the substantial risks that they pose to fundamental rights, there are very strict obligations being tied to the providers putting them on the market. So some examples of high-risk AI systems are those that are being deployed in sectors such as employment. So for example, as we're saying with the example of Amazon, if a company wants to deploy an AI system to fast track its process of employing new recruitments, then that would be considered high risk. The field of education is also considered high risk. Again, if universities want to deploy AI systems in order to fast track their process of choosing the right candidates to induct into, let's say, a master's degree, that would be also considered high risk. Critical infrastructure is an area where is also considered high risk. So if we are to integrate AI systems into critical infrastructure such as water management or natural gas management, that is also considered high risk. So if a provider wants to bring those kinds of applications into the single market, they can, but they have to follow a very strict process. They have to make sure, for example, that their data is as unbiased as possible. They also have to make sure that their systems are cyber secure, and they have also to make sure to analyze and mitigate potential risks stemming from their systems. Now, a final category that is worth talking about in kind of like the risk-based approach is also that yellow categorization there, which is considered to be the category of limited risk. Now, there it is this category, it is relevant to systems such as chatbots and deepfakes, where only transparency requirements are being applied. So the idea here being that the end consumer and the end receiver of this product must know that they're interacting with an AI product. So for example, if you are to speak to a customer service AI chatbot, you have the right, the provider has the obligation to be transparent about the fact that you are not speaking with a human actually, but you are speaking with an AI chatbot. Finally, there is also the category of minimal risk, where no specific regulation is being applied, but something that I wanted to also touch upon, and I will close with a pyramid after that, is that final category down there, that gray box that almost falls outside the risk-based approach, and that is the category of general purpose AI models. And there is a reason why that is outside the pyramid, and kind of like the idea here of the structure is that it permeates it horizontally. It is because those general purpose AI models do not pose a risk in and of themselves. However, they can become foundation models on top of which some high-risk AI application can be built upon. So that is more to reflect on the fact that the AI value chain and the AI market can be complex. It's not always that we have one provider putting a market on the product and they have to comply and to make sure that the risks are mitigated before they reach the consumer. But it is very often that some AI companies actually fine-tune foundation models that are being provided by a third party, fine-tune it by using their own data and make some little changes and then put it in the market. And so in order to reflect on that kind of like complex AI value chain that can be developed, EU regulators and EU lawmakers introduce that category of general purpose AI models. And their providers of those models must be very transparent in terms of the data they use to develop those models, and also in terms of foreseeable risks that they think could be transferred downstream to the fine-tuner, to the deployer as the law says, or even to the end user. And then I will stop sharing because I have stopped seeing all of you, and hopefully I can get my camera back. But that is the idea, that is the general idea of the spirit and law of the AI Act. Now, what happens if providers are not compliant with that structure and are not compliant with the obligations that are tied to that structure? Then very strict fines, very strict financial fines will be applied to the provider. So the highest fine that can be applied can reach up to 7.5 million euros. Or sorry, that is the lowest fine that can be applied. It can be up to 7.5 million euros or 1.5% of the company's global annual turnover. And that can reach up to 35 million euros or 7% of the company's global annual turnover. So you can see the financial punishment that the company can face if they're not compliant with the structure can be very severe. Now, we also have to mention, however, that also complying with that structure can also be very costly. So some studies, some impact assessments that have been performed have calculated that for companies in the high risk category that we covered, the cost of compliance can be anywhere between 100,000 euros to 300,000 euros just for the first year of operation. And after that, it could be an additional cost of about 70,000 euros every year in order to sustain those risk management systems, those quality management systems that are mandated by the AI Act. So this can also be very prohibitive to innovation coming from EU AI startups, EU AI providers. And that is something that the EU policymakers are also very aware of. And they are trying to mitigate both within the AI Act and also through supplementary action. So first of all, besides that kind of like legal risk based structure that we just talked about, the AI Act also talks about innovation measures. And one of the most significant innovation measures that are being mandated within the text are regulatory sandboxes. So every member state has the obligation to set up regulatory sandboxes that will act as physical and digital safe environments where developers can test their products under government supervision before launching them into the market and without becoming compliant with these obligations. And the intention behind this is to provide a safe space for experimentation without the fear of being fined. Now, these are some innovation measures that are included in the AI Act itself. However, especially in the last couple of months, as we see the European Commission is shifting towards a focus on competitiveness, we see some additional measures as well that have the aim to counterbalance potential compliance costs and potential legal uncertainty that the AI Act is posing to innovators. So most notably, the President of the European Commission, Ursula von der Leyen, announced very recently that the EU would launch a new Invest AI initiative that would mobilize about 50 billion euros for AI innovation. And out of that 50 billion euros, about 20 billion euros will be directed to a European AI fund that is supposed to also help European startups, supporting them with research and development activities, and potentially with some compliance support as well, which has been requested by a lot of parliamentarians as well in the past. And finally, in addition to that, 50 billion euros being committed to the Invest AI instrument, something that we also need to talk about is the AI Factories Initiative, which aims to mobilize about 2.5 billion euros in order to provide European startups and innovators with computing capabilities, with computing resources, in order to be able to cut down on their costs of training AI models. So in order to conclude this presentation and leave us some more time for conversation as well, if we are to describe the EU's approach in one word, that would be balance. So on one hand, we want to regulate the risks that AI systems pose for fundamental rights and for citizens and consumers. But on the other hand, we also want to support innovators to not stifle AI competitiveness in Europe and hopefully reap the benefits that the AI revolution brings, whether that is in science or whether that is in manufacturing or whether that is in terms of economic benefits that can provide to Europeans. So thank you very much for your attention, and I look forward to discussing some of this further in the discussion.
Thank you, Giorgos. Maybe for the camera to unfreeze, maybe you can just turn it off and on. Maybe that could help. Yeah, we can see now. Thank you for the great presentation. Sara, I kindly invite you to go next. The floor is yours. Thank you.
Yes. Thank you, Christy, Anna, and all the organizers. I'm really happy to participate in this discussion. I really appreciated some of the data that Giorgos has shared that I didn't have. So I'm afraid my presentation has a little bit of an academic flair, but it's very short. I'll try to keep it short. So let me share my slides first. Can everybody see the slides? Yes?
Yes.
Okay. So when we got in touch, we thought about having this comparative view of what the EU is doing and what China is doing. So my slide actually already incorporate that comparative perspective. But because the previous presentations been so comprehensive about the EU, I will try to focus on China. And I will try to do two things. The first one is to look really from a kind of bird's eye view at the regulatory approach of these two main global regulators, and see how it is different, and maybe also how it is actually not that different, for the first point. And later I have one slide only about some regulatory choices, about the questions that are still open or only partially regulated, that both states have to deal with, and try to have that comparative view in an horizontal way, looking at one subject and seeing what's happening on the two sides of the world. Before doing that, actually my first slide is a little bit of conceptual framework, because we have to remember when we talk about what the EU is doing or China, when we want to compare them, that this happens against the backdrop of the whole world trying to figure out what we can do with AI, should be regulated, and how. So there is the big picture of AI governance that we have to keep in mind when we go into looking at one regulator or two regulators together. So the 4 points that I want to make about this are on the slide. So the first one is that, contrary to what sometimes is the message or the narrative of the industry, of the providers of this technology, AI is not something that you can define as a standalone technology, something very special, something that should be considered in itself different from everything else. Actually, a lot of studies, you have some references on the slide, point out that AI itself is an ecosystem, a digital ecosystem that includes things like hardware, and Giorgos was just talking about computing. It includes software, obviously, it includes data. So there's a lot that goes under the umbrella term of AI. And as a consequence, that's my second point, also AI governance is a puzzle. Although we would like to have an AI law that just solves AI, a big equation, right? One equation that solves everything, I think it's impossible, because we are looking at different layers, different things that have been regulated differently for so long, and nothing is going to put them together just in one go. The third point that I usually make when I try to speak about AI governance and global AI governance is that we can think of this regulatory area, this AI governance, as a global regulatory space. And the global regulatory space is a metaphor that has been used in legal and political science studies to define these areas of social life where more than one regulator, more than one actor has a claim to regulate, and also the resources to do so. So this was, I think, was particularly true a few years ago. I think it has been existed for like the last 10 years, and it was particularly true until 2, 3, 4 years ago. Now the space is closing up a little bit because big regulators have grabbed that space. And by that also mean for some things we have decided that we're not going to regulate for now. That is also a regulatory choice. So the space is closing up, but it's also true that many regulators, many actors are there. The big tech companies, the big states, stakeholders at the international level, like the UN, many UN agencies, and also other stakeholders, like from the World Economic Forum to the little charity that is looking at AI discrimination in a certain neighborhood or city. All those stakeholders have some sort of regulatory claim in the space. And so we can think of it as such. And my last point, and I think that also joins what has already been said, also by Christy, that we have this framework that it's widely accepted, has been put forward by Professor Bradford, that the EU, China, and the US provide 3 very different models for regulation. The US is market-driven, so the invisible hand of the market will take care of it. The EU is rights-based, and China is techno-nationalist. I can never really remember it because it's not really my experience. But overall, I think this framework is very useful because it kind of explains a lot of things. And of course, the book is very nuanced and it explains how these frameworks clash and overlap. But I think that we can add to it that, yes, it's true, there's 3 models that seem very different. But if we zoom in on particular issues, for example, it's not today's topic, but I'm working on the regulation of algorithms, choosing algorithms as a regulatory object, especially within social media and platforms. And I think if we look at the regulation of only that part of AI, algorithms, actually there are many similarities between what China is doing, what the EU has done, and also some the 2 regulators seems to draw inspiration from each other. And of course, how it is implemented, it depends on the legal culture. It's not the same, but there are similarities. Data protection is another one. Of course, there's a big difference as well there, but there are also similarities. And so I think we can choose what to focus on. We can focus on the differences, but we can also focus on what's actually similar, because the problems are the same. And sometimes regulators will actually draw inspiration from each other because there's very low path dependence in this field. Right, that's for the big picture. China's approach to generative AI, you have a link to a paper that is, of course, more detailed than what I can present now. So, but if we go back to that November or December 2022, where ChatGPT was released, and so the public discovered generative AI, me first, I wasn't really aware of that particular type of AI. So that launch, I think, happened in November or December 2022. And China actually put out the first legally binding text on generative AI. They're called the interim measures on generative AI. They entered into force in August 2023. And the process was that already in April of that year, so just 4 months after the release of ChatGPT, the first draft text was released for public comment, and then people comment, the industry and some colleagues back in the mainland were asked to give opinions. And then after that, in August, there was a definitive text that would take into account of those comments and enter into force. So it is true that this is not a comprehensive AI law like the AI Act is this ambition to be, but I would claim is the first actually text about generative AI that I'm aware of in so specifically and so fast released. And so one could ask why and how it happened in China that this happened so quickly. We know how difficult the process to arrive to the approval of the AI Act was in the European Union. So how is different? So first of all, this is a smaller text. But there are a few things that kind of explain how that works. So as Machian has put forward, and others as well, Angela Jung, they have a lot on this. China has been using this very fast-paced policymaking, choosing to go with very specific regulations that are legally binding, but also are not laws. So they are, administrative level regulations that, again, legally binding and enforceable, but they're not complex laws. They require much longer procedure to be drafted and then approved. And so this has been going on in digital law in China for more than a decade. And then some of those rules have been consolidated in laws like the cybersecurity law or the PIPL, the Personal Information Protection Law. And this has also happened in the field of AI. So deepfakes and recommendations on social media have also been regulated before in 2022, 2021, with the same kind of process, very fast paced, with public release of a draft text, with comments and then approval. This particular mode of governance has been existing for a while, but the renewal of the role of the Cyberspace Administration of China seems to have been really an important change that has allowed this particular agency to kind of bring together all the other agencies and guide the policy making and kind of regulatory momentum. And also, I would claim that there is work that is done in scholarly work, but also policy frameworks that have been put out in the past years, not only about AI, but about what is good administration, what is good policy making, what is good, what are the good rules. And so there is a framework that kind of gives them overarching idea of what should be achieved by a legally binding text. And again, I'm not claiming that this is particularly comprehensive or perfect. And to these days, we are a little bit unsure how the enforcement of these measures actually works. But in terms of showing the industry that this is not an unregulated market, it won't be an unregulated market, there will be rules, that kind of goes a long way. And also, if we think about the content of these measures, one of the things that they make quite clear is that every existing law, insofar as it is relevant, it applies to AI, which again seems kind of very simple, but it's sometimes counterintuitive, because what we're told is that this is so special that, you know, there should be some kind of regulatory leeway, and that wasn't the case for China. So moving to the EU, and I'll be brief and I won't touch upon what has already been said. Regarding specifically generative AI, I would say that I find myself with others in disagreement with the idea that the AI Act wasn't ready for generative AI for a few reasons. It is true that the draft AI Act was, you know, written and put out before generative AI became a commercial product. But if you think, for example, about the definition of AI that was there since the beginning, that actually can already cover the definition, sorry, of an AI system that was there from the since the beginning actually covers already generative AI. So yes, the wording has been tweaked. Now we have AI systems and general purpose AI systems in that regulation. But with other scholars, I think there is a strong argument to say that that particular bit of the regulation wasn't outdated. What was outdated, even before it was entering into force, was the idea that AI could have one purpose and one purpose only, right? So AI systems to be used in migration or law enforcement are high risk. But then what happens if someone uses ChatGPT in those sectors, right? So that was really something that something had to be done about it. So I think we need a lot of guidelines and explanations yet, but from my reading of the Act, what I understand is that the models, so the GPT model, for example, any foundation model that underpins any generative AI commercial product, that is a general purpose model, and there is regulation for that, especially if for the big models that could have systemic risks. But anything else that is generative AI commercial product, like ChatGPT with an interface, that is an AI system, and it falls into the regulation of that. And so though general purpose AI systems are not high risk, when used in high risk areas, they can be regulated the same way. There are a few provisions that allow that. So the reading is not completely incoherent with that, and I think it makes sense. Last point about the EU is that we have this AI law, but it's not, as I mentioned, the equation that solves everything. There's so many other instruments that apply to generative AI. First and foremost, all but gold GDPR, where we are seeing the data protection authorities of Europe trying to use the GDPR to regulate at least some aspect of the use of generative AI products, such as ChatGPT and DeepSeek. They all been under scrutiny, or in Italy, particularly my home country, but not only, many data protection authorities have been using the GDPR when generative AI was in question for generative AI-based products. And we also have from recently decision of the Court of Justice about credit scoring that has been adjudicated on the grounds of Article 22 of the GDPR, but actually, you know, kind of also applies to things very similar to the Dutch welfare adjudication scandal that was mentioned before. So there's a new product liability directive. So the old product liability directive from the 80s has been completely rewritten, made more complicated, and it will enter into force. It will be fully applicable in 2026. It is already in force. And it has been modified in great part to be made coherent with the AI Act. So with the idea that the AI Act would regulate the pre-market operations and some of the monitoring that happens after, and any change in the requirements that you have to do before. If that happens after marketization, then the AI Act applies. But if something goes wrong, if there's harm in terms of personal injury or harm to property, then the Product Liability Directive is the one that is applicable. And that also kind of, I think, was one of the reasons why the all text of an AI liability directive that had been pending has been repealed. It wasn't very in line with everything else. So I think that was one of the reasons why it was repealed. And again, the copyright directive, there's so much in the European Union that is outside of the AI Act, and that is relevant to generative AI. And again, it applies to generative AI. We just have to wait for enforcement and for the different enforcement authorities to kind of engage with it. And that is true also for China. It's one of the big similarities. I think it's true for everybody. We have to accept that we are in a transitional period. We are witnessing this revolution, if we want to call it like that, as it happens. And we have to accept that you know, we are going trial and error. And it's very good that we have differences among what the regulators are doing, because we can choose what works best down the line. But at the same time, there will be loopholes, and that's just normal. So for my last point, if we want to try and compare what China and the EU are doing on certain issues, I just put some on the screen. They're small, and maybe I don't have the time to do everything. But I would say, if we pick, for example, IP rights, and we stick to what we know so far about China, that, for example, the interim measures tell us that as a principle, training of AI models should respect existing IP rights. Whatever that means in practice, yeah, that's a different story. But in principle, it should respect. That's kind of very different from what we have in the European Union, which is an exception for the training of AI in the copyright directive. So that is very, very different. But then if we go to, for example, data protection, and we read the data protection legislation, there's a lot of similarities between the two, and a lot of emphasis on the same things like transparency, autonomy, with some differences. In particular, the role of the state is different. But if we focus on data protection vis-a-vis companies, we have a very similar framework that is based on consent, and anonymization of data and choice, and information about whether you are being decided upon by an AI system, and things like that. Another area where we have a lot of differences is the perception of what is high risk. Again, some things will be similar, but some things are really different. Obviously, law enforcement, but also the justice system. So in China, I'm sure you're all aware, all the people in this room are aware about China, that it is very common for courts across the country to hold hearings online. So people that have to be in a hearing, lawyers and parties, they can just use WeChat on their phone while on the train and sit in the hearing, which is impossible to think in Europe. So digitalization of justice has been going very fast in China. And of course, it's been accelerated by COVID. And now there's a lot of uptake of AI system in the justice system across the board, from, police services to really support of judges, to even arbitral institutions using AI to support decision-making. So, and in general, I think this uptake is seen as a good thing, not just at the policy level, but, with the people that work in the justice system and the citizens themselves, they see it as a plus because it's very convenient. And that really very, very kind of mirrors a general trend in China, where people are usually very, very open to new technology. They are early adopters of technologies as a whole. This is something that works in many fields. And so that is really very different culturally. So in the European Union, we know that use of AI system for adjudication in courts and even in arbitral proceedings between commercial parties is considered a high-risk use. And so there's a lot to be said about how this will be implemented and if this will actually block the uptake of AI altogether, because it's so hard to comply, especially for courts where there are very little resources nowadays, and there are no people that have these special skills because there's already resources are very, very small. So it is quite difficult to imagine how this having compliance frameworks could be squared with also fostering the uptake of AI in the justice system. And whether we think that's good or not, it's a big difference between the two systems. So I think, again, I'm going to stop here because I could talk about this for long. But the idea is that if we engage in dialogue, we're going to find common ground. And even if we don't adopt the same solution, I think we're all regulators are facing the same problems. And so we should see differences not as clashes, but as experiments in this transitional phase. Thank you.
Thank you, Giorgos and Sara, for your presentations and for outlining the regulatory context in both the EU and China. At this point, I'd like to open the floor to the audience. I don't know if you have any questions for our speakers. Please feel free to raise your hand or use the chat function. You'll also have the opportunity to ask questions during the latter part of the session. So. Participants would like to ask any questions. If not, Hannah?
Yes, hello. Thank you so much to both speakers for this presentation. I had a short question, actually, a bit more to Sara, but maybe also Giorgos, to both of you. In terms of the general approach, considering the EU, China, and the US in this, let's say, regulatory triangle, since you have mentioned that the US is more market-driven regarding the regulatory approach on AI, so I'm actually wondering if you would consider the European and the Chinese approach rather close in terms of a bottom-up regulation of the systems that we have on AI, and while in the US it would be more bottom-up, market-driven. I don't know. This is a bit the thoughts which I have right now, and it would be interesting to hear your opinion.
Should I go first? Okay. So I think even if we leave the field of AI for a moment, there is a similarity between China and the EU, is how big the state apparatus is and the state machinery. So there are resources and there are people that work in agencies that can monitor the market in many, many different fields. And there is also a history in both places for different reasons for a much more important presence of the state when it comes to regulation. And of course, that is also what's happening in AI. I mean, it couldn't go any other way. There's a lot of path dependence in that way. But at the same time, I think we should mention that in the US, we can say it's market-driven, but it's not that there's no regulation at all. There's no regulation at federal level because the federal state needs to keep lean. That's the idea, right? The regulatory culture. But then states have been doing things, not just California. We know that California has the more developed, or allegedly the more developed, data protection framework, and especially focusing on minors and other things. But there are examples of certain states in the US taking the lead. For example, the classic example is Illinois with the Biometric Regulation Act, BIPA, Biometric Information Protection Act. That is an act of 2008, I think. And so even though it hasn't been followed by other states, it was kind of a pioneer experiment into, let's see if we can kind of rein in the use of facial recognition technology in particular. So it is again, these frameworks, they work very well. They explain a lot. But if you look a little bit closer, things are a little bit more complicated. Yeah, so that would be my initial reaction.
Yeah, I completely agree with Sara, and I think as Sara was saying, it's very interesting. We really, especially Anna Bradford dubs the U.S. techno-libertarianism, and that is true very much so, especially with the latest administration. One of the first decisions of President Trump was to repeal the executive order on AI that the Biden administration had adopted, and that was started to provide a little bit of a blueprint for an AI governance a scheme in the US, but that was repealed. But as Sara was saying, we also have to think of the state level and the role that it plays in the US federal government system. I read something very interesting this week, actually, that just in 2025, there were over 700 AI-related bills being proposed across US states. So you can see also that how much that plays into it. And if we are to compare that with the EU, something that we also have to talk about is there is a lot of discussion about how the EU sometimes might overregulate or move too fast to fields that are quite emerging. We have to think, however, that one of the alternatives of having an AI Act is not having no AI regulation, but it is potentially every EU member state having its own AI regulation, and that would create severe fragmentation across the single market, and that is also something we want to avoid. We want to avoid also having hundreds of AI proposals coming up in Germany, in Greece, in France, and elsewhere, and the AI Act provides at least that kind of like harmonizing effect.
We have a question from Javier Boras. The floor is yours.
Yes. Hello. Can you hear me?
Yes.
Okay. Thank you, both speakers. It was a very interesting conversation. And I have a question for Sara. Has the appearance of DeepSeek changed in any way the debate on AI regulation in China in the recent months?
My short answer to that is no. I think in general, so I think people were surprised slightly that DeepSeek performed or is performing as well as it is. But overall, there are so many AI applications that are released every day in China about so many things. Like you can buy a car in mainland China now that without AI that parks for you. Like there's no option out there. So if you want a non-AI car. So I think that is part of the system. And again, we think of the US as, they're market driven and fostering innovation. But China has its own way of doing that. And so I think not only DeepSeek didn't change anything, but actually reinforced the idea that whatever is happening there and actually here in this side of the world is working as well as whatever is being done elsewhere for the moment. We're always waiting for the next big thing to happen, but for the moment, I think it kind of reinforced the belief that this type of regulation is working.
Thank you, Sara. It seems we've already transitioned into the discussion round, so maybe we can continue the conversation from here. Let me just quickly share my screen again and show you the three guiding questions. So maybe we can start by tackling the first one. What challenges do China and the EU face in integrating generative AI, particularly regarding ethics, data privacy, public acceptance, and how do they ensure accountability for harms like misinformation, deepfakes, or bias? I don't know if either of you like to go first.
Yeah, if I can, Christy, actually continue a little bit with the DeepSeek conversation, and relates a lot to the question that we're talking about right now here as well, because especially when we talk about accountability, one of the main forms that we can ensure that is through regulation. I think a big challenge that is worth talking a little bit about is how to make these AI regulations agile enough that they catch up to the technological developments. And that is very much tied to both ChatGPT and DeepSeek, because at both these kind of like pivotal moments in terms of AI development, the AI Act was very much caught off guard. So as Sara was saying, the advent of ChatGPT made policymakers realize that a lot of the general purpose AI systems were being left outside of the scope of the AI Act as it was being drafted, or that they would be included, but it wasn't as clear as it became after ChatGPT when the amendments were introduced. And now with DeepSeek as well, there is also something we have to also keep in mind is that the AI Act takes into consideration computing power, especially in terms of what they call general purpose AI systems that pose systemic risks. Those are very much defined by how much computing power its AI model uses. The challenge that DeepSeek brings here is that by allegedly using less and less computing power in order to achieve those impressive results, we may start seeing a lot of the AI systems that policymakers thought would be regulated that way falling outside the scope of the AI Act. So the conclusion here, besides these technicalities, is that it's becoming very apparent that it's very hard to keep up with these technological developments by having like one inagile piece of legislation trying to regulate such a fast-moving technology. So I think something that is also very interesting to consider here is the role of how we can make that more adjustable. In the EU, there are tools of secondary legislation, there are tools of consultative processes with things such as the AI board, and how that can help adjust the regulation in the future. But these harms, they keep evolving. So our regulations and our accountability mechanisms must also evolve. So those are some primary thoughts about that.
Yeah, so this is a very broad question. So I think, as I mentioned, there are challenges that are very, very similar across the board. So ethics is one of them. I think everywhere we can agree on some ethical principle. We actually have a UN convention that allegedly virtually every state in the world has signed about what are fundamental rights. But then when we go into the details, we probably don't agree. So I think ethics, the real challenge is trying to take all views into account. So I was recently at Tribal AI, where there is a technical program. So people who are working on AI systems kind of share their research. And I think one of the issues that is more debated is alignment. How can you build a system that somehow takes into account different views about the same thing? So ethics, again, it's a problem of diversity and also discrimination, but diversity more generally, I would say, that exists everywhere. Public acceptance, on the other hand, is something that I see, as I mentioned before, is different in Asia, in particular in Greater China, where public acceptance is not a problem. There's much less resistance regarding the use of AI. And I was thinking before I joined, how similar actually it is to go through immigration if you are, between Hong Kong and China, or in the US, even, domestic flight in the US, or when you arrive, that there's a lot of biometric identification and facial recognition, and you can cross from Macau to Zhuhai just showing your corneas, and you can pretty much do the same if you register with facial recognition in the US. So I think China, from this point of view, and the US are more kind of accepting the convenience also that comes with it, while in the European Union, the considerations about rights are very, very much felt by people. So I've had colleagues that come to Asia, not just in Hong Kong, but maybe Singapore, and feel the difference about how much surveillance and use of biometrics there is here, but I don't think people here particularly notice it. So the public acceptance bit, I think, is one where the challenges are different, in the sense that here there are much less challenges from that. When you talk about accountability of harms, I think all of those, misinformation, deepfakes, and bias, they have a collective dimension to it. And I think this is important to kind of notice with AI, and it's very similar to privacy in the digital world as well. So it's a problem that has emerged 10 years, 15 years ago, and it's now exacerbated by AI. That is the fact that maybe AI can harm us individually very little, and in a way that we cannot really perceive. But if we look at the collective societal level, those harms can actually be very, very important. So if you are the victim of a deepfake, you can be harmed. But what happens if we don't know what's real anymore? That's a different level of harm. The same with misinformation, biases. You can be discriminated, but we have laws that allows you, for example, to sue an employer, to sue Amazon if they discriminated against you in a hiring process. And you might actually get compensation for that. But what happens if that is what goes on every single time? That's a different. So I think the collective level of harms, the legal system is totally inequipped to deal with. And so that is a challenge that exists everywhere.
Okay, thank you for your responses. We can then move on to the next question. How are China and the EU supporting innovation ecosystems for generative AI, and what are the key barriers to collaboration across borders? Maybe Giorgos, would you like to go first?
Yeah, sure. I mean, let me start saying, I mentioned this a little bit, but one of the main preoccupation right now at the EU level is this kind of like lack of AI innovation coming from the European Union. So, when you look at the data, it's only about 3% of the world's unicorn AI startups that are coming from Europe. And especially, there is also like a significant lack of national champions. You look at US providers, and you have OpenAI, Anthropic, DeepMind came out from the UK, DeepSeek now coming out of China, but not really any European champions coming up. There is the case of Mistral, which is very interesting, but even there, it can be argued that they are completely dependent on Microsoft for their computing power, for example, and that without that very much like the US AI infrastructure, their development could be halted. So right now, as I was saying, one of the main priorities in the EU's agenda is supporting its AI innovation ecosystem. That happens in a few different ways. As I said in the beginning, the regulatory sandbox regime is something that's very important, and that is more of a kind of like a compliance supporting measure, right? So the idea there is to make compliance as easy as possible for those innovators trying to bring high-risk AI systems into the single market. So that has to do more with compliance. There are a lot of initiatives, as I was saying, in terms of compute, because compute is such an expensive component of AI innovation. The EU is stepping in and providing funding in order for supercomputers to be built across EU member states. And now there is also a very interesting initiative about building 4 AI gigafactories across the European Union, and which are also supposed to host about 100,000 cutting-edge AI chips. And the details about that haven't yet been released, if the access to that will be completely free, if there will be given priority to some European startups with a discounted price. But the spirit of all these initiatives is essentially to help innovators cut down some of the cost of compute and let them focus more on actually building their products and AI systems. And finally, there is a lot of initiatives, as we're saying, in terms of the innovation part itself, of building the algorithms, of building these systems. We talked a little bit about this upcoming European AI fund, which is going to be about 20 billion euros. But we must also not forget that Europe hosts one of the biggest basic science funding schemes in the world, Horizon Europe, which in total is 100 billion euros over the span of 7 years. And that, of course, spans across many sectors, not only AI, not only technology, it spans across things such as green tech and basic science as well. But we will see, I think, a lot more initiatives, especially since from 2027, Horizon is supposed to be renewed and a new kind of like program is supposed to be spawned out of it. And we might see a lot more focus and a lot more funding dedicated to AI innovation through that as well. This was very much something that was recommended by Mario Draghi himself in his high-level report on European competitiveness, who said that not only should the Horizon funding be focused more on strategic sectors such as AI, but that Horizon should also be doubled and go from 100 billion to 200 billion euros. Now, if that's going to be realized, we'll have to see. But there is definitely the financial capacity for the European Union to support these innovators. And finally, another element, but I'm not going to spend any time on it. But again, we also have to think of the member states level and how individual member states have their own schemes to help innovators as well. And that, of course, differs from France to Germany to Greece, but it all comes down together for these companies at the end of the day.
Thank you, Giorgos. Sara, would you like to add something?
Yes, so I think China, I don't have the numbers, and I'm really thankful, Giorgos, that I'm learning so much from all this data about the EU. I don't have the number about China, but I'm sure I could bet they're very high as well in terms of supporting innovation. I know there's a scheme about sharing supercomputer and make sure that time on a supercomputer is kind of allocated quite efficiently among different stakeholders, no matter who's the owner of that, the state or some of the big techs. So I think as in many sectors, the problem is not the support that the overall ecosystem gets from the Chinese state. But you know, as I was thinking about your question, I think that all the barriers to collaboration are not related to AI itself or to what states are doing or the EU is doing to support innovation, but we live in a very fractured world. I think everybody is aware of that. So really the key barriers to collaboration are barriers related to the mistrust that exists today between the two areas and also across many other areas. And I think it is quite, for a lawyer, it is quite fun because, of course, it's a mistrust situation. I wouldn't trust, you know, I don't know, my data to be held in China or the data of some Chinese company to be held in Europe because, digital sovereignty and so on. So it's a problem of trust, but for a lawyer, it's fun because actually trust doesn't really work in these complex systems. The proxy for trust are rules. So if we had rules, maybe we could actually collaborate better because we would have some kind of level playing field. But at the global level, there are some initiatives, and we had a lot of reflection about the ethics of AI and even things like how do we define AI and those things have been thought through, but there's really no, for example, there's I think it's not my field, but a lot of discussion about how we're going to consider AI when it comes to trade and the existing rules of trade. Is it the service, is the good? There are a lot of things that are still debated. And so I think if we don't get the regulatory part right, especially at the global level, that mistrust cannot be really overcome. And of course, the geopolitical conditions are not very conducive for that. But so I'm sorry that I don't have a more hopeful answer to that.
Thank you. Thank you to both of you. Maybe moving to the last question. Sara already touched on this earlier during their presentation, but how do China and the EU converge in their regulatory strategies for governing AI? Maybe Joseph, you would like to go first.
Yeah, I mean, as you said, Sarah covered this very extensively, but maybe, a remark that I think is worth mentioning is, as Sarah already said, like the multiplicity of the EU's AI framework is quite similar in that sense. And by multiplicity, I mean that, as Sarah was explaining, this shouldn't really be seen as this kind of like law that focuses on one thing, that is AI, but there is this ecosystem approach where different laws interact with the AI Act and also different instruments as well. So going back to, let's say, the high risk AI categorization, we talked a few new use cases that the AI Act brings forward. What we didn't talk about is also a lot of the older laws when it comes to like machinery, when it comes to medical devices, when it comes to even things such as lifts, that are also integrated into the AI Act and cut horizontally. So these are not laws that are being repealed, but rather the AI Act provides an added element. They're like building blocks, one on top of each other. So when we're having AI systems, let's say, integrated into lifts, both these laws apply. So I think that is something very interesting that Sara also mentioned about how essentially takes place as well, in the regulatory strategy of China, that these laws are cross-cutting, and yeah, that's my biggest observation from this.
Yeah, without repeating what I just said, I think there is convergence, not just between the EU and China, but for example, China and the US in some sectors, and that is to be expected, because in other sectors that have been global before, we have seen this. And I would just say something that I didn't mention before, but this convergence, it's not necessarily good. In the sense that sometimes regulators might copy rules or be inspired with rules that are not the most efficient ones. So convergence is good, but hopefully we would converge on standards that are those that we prefer. So, for example, I hope that in data privacy we will go past consent as the thing that we are all happy with, because we know that consent most of the time doesn't work. It's not real consent. And so I just hope to see that convergence on things that go beyond what seems to be the general mood. Yeah, that would be my remarks.
Okay, thank you. Thank you to both of our speakers for their insights. Since we've already taken a few questions earlier, this is a final chance to ask any remaining ones. As always, feel free to raise your hand or drop your questions in the chat, and we'll be happy to read them. Questions? Okay, so since there are no further questions, maybe we can wrap up today's session. Before doing that, I'd like to sincerely thank Giorgos and especially Sara for joining us, particularly at such a late hour. We truly appreciate it. Big thank you as well to all the participants who joined us today. Don't forget to follow European Guanxi on social media to stay up to date with our latest publications and upcoming events. And yeah, thanks again. Have a great weekend. Thank you.
Thank you, everyone.
Thank you. Thank you.
Thank you. Have a great evening.
You too.